Hello, everyone, and welcome to this session on the Pro Se Litigant with Katherine Alteneder. Katherine is the Consulting Senior Strategic Advisor to the Self Represented Litigant Network, which she built into a broad international network of justice system and allied professionals who are creating innovative and evidence-based solutions so that self-represented litigants have meaningful access to the courts and get the legal help they need. She now serves as the consulting senior strategic advisor and guides the network's many activities designed to grow the justice ecosystem and strengthen each part of the legal help continuum. Before joining the network in 2013, Katherine spent her career in Alaska, initially as a trial court law clerk and then as a legal aid lawyer. In 2001, she joined the Alaska court system as the founding director of the nation's first comprehensive phone and internet-based court self-help center. In 2008, Katherine established a successful unbundled practice and found the first unbundled law section of a state bar. Katherine is a frequent speaker and serves on numerous advisory bodies, including the Advisory Committee for Voices for Civil Justice, Village Capital's Justice Tech Advisory Board, and the National Center for State Courts Justice for All Projects. She is also a non-resident senior fellow at the Georgetown Institute for Technology, Law, and Policy. She received the National Center for State Courts Distinguished Service Award in 2019 for her work to improve access to justice. Katherine has a BA from Northwestern University and a JD from Seattle University School of Law and resides in Virginia. She especially enjoys opportunities to mentor those who are seeking a career path in access to justice and public interest law. So thank you, Katherine, for being here today, and take it over.
Thank you so much, Kathy, for that lovely introduction. Good afternoon, everyone. Kathy left out the most important part is I've been to Florida a few times to do some work in your state, and I'm always just so impressed and inspired by the work you all do. So it's a real treat to be here today. I know it's the end of a long day for you all, and you've had lots of conferencing. So hopefully we can hold your interest and that you can leave this session with some concrete ideas to help support your days and make your practice easier. The presentation is going to cover about 3 buckets, essentially, sort of the discovery of a legal problem for a self-represented person, the journey, the justice journey that the senior goes on, and some strategies for success for you all. So what legal problem, right? This is the first and really, I think, the most challenging thing for folks. There's so many things going on in somebody's life, many challenges, and what is actually a legal problem and what is not a legal problem. And we all know that often clients come to us, if they'd only come to us a little bit earlier, we could have had an upstream intervention of some sort to help them out. The thing that they think is a problem is not actually a legal problem. When I practiced family law, I used to say to my clients, all cases are emotionally complex. Only a few cases are legally complex, and figuring out really where the legal issues are. And so our role, even with self-represented litigants, I think the most powerful thing, there's a couple really powerful things we do. One is we help them figure out what is a legal problem, what their options are, and help them understand the process around that so they can make an informed decision of how to proceed. So I wanted to, I know it's late in the day, so I'm hoping we can have a little bit of interactivity, and I have a little link for a word cloud that I wanted you all to help share with me. What are some of the challenges that you see seniors having in discovering they have a legal problem? And bear with me while I get I'm going to put in the chat a link, and if you click on it, you should be able to enter some thoughts about that. And then I'm going to screen share as you enter it. And so just a couple of words, just to give us a sense or what you see as the most pressing challenges that seniors have in discovering a legal problem and understanding that what the problem they're facing is in fact a legal problem. And so far, I don't see any responses. Let me check the chat if people are having difficulty with that.
I don't see anything in the chat yet from anyone that's having difficulty. Do you, is it possible to put this in the chat? Just, it won't get, but it won't go on your Word.
Oh, there we go. I see some.
Okay.
Some
Okay.
are coming. We have a couple.
Okay.
I'm going to give you a couple more minutes because these were not the first two I thought. So then that's even more exciting, right?
So someone did write in the chat, they weren't able to access the link, but one of the suggestions was that they would have put in there was possible dementia on the part of the senior.
Excellent. And other words that we're seeing come across, fees, proving their case, and case filing challenges. So I think those are the main responses. Oh, now we saw a whole bunch. There we go. All right. Hold on one second. My screen is going to stop sharing and then it will share again. Oh, a whole bunch just dumped in. So hang on one second.
All right, we can do that. Someone else has included how to obtain legal representation due to limited finances in the regular chat.
Great. Sort of now it just disappeared. There we go. Okay. Okay. So we should be seeing some of the words that is that visible to you all?
Yep. Yes, it's
Okay.
it's on the screen.
Wonderful. So, you know, these are, and as we move through this presentation, I'm hoping to give you some strategies of how to create an environment from beginning to end that will help support these, because a lot of this, many of these, right, are about identifying that they have a legal problem, about just having information of how things go together. Then there's the piece of actually having a case. And those two buckets are slightly different. And I think there are many things that you can do to help work with that. So I will be able to save these word clouds and I will send them when Kathy will have the materials to upload, because I think they're nice reminders of what we'll be looking at. So now I'm going to try and be tricky again. Okay, we should be back to the regular PowerPoint. So
It's not in slideshow format though.
correct. There we go.
There we go.
Okay. So I want you to hold on to those challenges for a minute, and I'm going to broaden our perspective now and just share some information that you may be aware of. In 2021, the Isles and Hill, which is an international access to justice research body in the Netherlands, did a survey of 10,000 Americans to see really what their justice needs were. And the full report is available at the URL I provide, but I want to, but we can segment by age. And I want to highlight some of the things that this report said. And I want to note this is, normed over the entire country. They were trying to get all demographic groups and so forth, but it gives us a sense, at least from a national perspective. And also the idea of how important gathering data about what's going on, being able to tell this story to other funders and supporters that might support our work. So and I encourage you, when you have a chance, to go to their webpage on the URL I showed. They have a data dashboard you can go into. And what these are screenshots from that. And in the right-hand corner, you can see under age, the over 60 is blacked out. So I've just filtered for the over 60 folks. So this is on average, as people reported in these surveys, they have 3.64 or the mean number of problems over the last 4 years. And I have not filtered by household income. I've allowed the entire income range to be present. And then when we go to prevalence of legal problems, the category of legal problems, and it might be very small in the screen for you to read, so I'm just going to read from left to right. Consumer issues, and then personal injury, neighbor problems, crime problems, money related, traffic, parking, work and employment, family problems, public benefits, government services, housing problems, domestic violence and abuse, land problems, police, and immigration. And one thing we see consistently nationally is that consumer problems are often more of a problem than we think, or at least the priorities in many legal aid offices often land in family. This next slide, I think, is very telling about helping us understand, and again, so what is that legal problem? Where is it? What is it? Which of the following best describes why you didn't seek information or advice from a lawyer? 28% of the respondents said a lawyer was not necessary. In other words, they just didn't think it was a legal problem requiring a lawyer. And if you think back to that word cloud that you all had, the issues and problems that you identified were problems that somebody with legal training would understand as a problem. In other words, if you didn't have legal training, you wouldn't understand that those are the places that you would get snagged up. And that's really where a client needs the most support. The second category, the issue was not appropriate for a lawyer, 17%. The third category, my issue was not a legal issue, 16%. The next one, I preferred to handle the issue myself. So we see in the top four categories, basically a client or the public making this determination that this really isn't something that needs legal help. I can either figure it out or it isn't a legal problem. This kind of information, I think, can be very helpful for us when we think about how we approach and engage our clients and understanding where they're coming from, how we think about doing outreach, how we think about engaging partners, and why partnerships are so vital. And when we do that education and cross-training with non-lawyer partners, they serve as the trusted intermediaries with the seniors and can help them understand why a lawyer might be useful. The next slide talks about what legal information, advice, or services did your source provide? And so I've just selected some of the pieces of data that were available from the report, but they segment like all the different kinds of helpers one might have. And besides lawyers, there are things like medical professionals, police, insurance agents, so forth, just anybody in your community you might talk to, religious leaders. And the number one thing that people identified as what they actually provided, their trusted helper provided, is that they helped them to understand what to do to solve a problem, 16%. The next one is gave me emotional support, 15%. So the top, we combine those, that's 30%. or more is really just about listening, supporting them, and helping them how to understand what the process is and breaking down the steps. The next category, advised of my rights and legal options. And that can be read, I think, a couple of different ways. As people are making decisions, and we are gonna talk about this later in the presentation, of really giving them options and ensuring that they have autonomy in the work that they do, in their life that they do, and I think an agency, and giving them options and advising them of their rights is a critical important. And I think this is particularly true for seniors. They've lived a long, rich life. They have a lot of judgment, and it is important to really ensure that we give them the agency to make decisions in their life. I'll just add another thing about this. I know oftentimes the number of client inquiries are far exceed who you can provide. So, the help you can provide. So you're in a situation where you might be doing some just brief service or advice and counsel. And I think what you're hearing in the first 4 categories of this is that's exactly what people are looking for, and that it means a tremendous amount. And I think sometimes as lawyers, we feel like we're not doing enough if we haven't taken the case and become this, the full representation lawyer, and taken this all the way through the process, that somehow it's something less to do brief advice or advice and counsel, brief service or advice and counsel. And it turns out it's really not. It is a very meaningful and respectful thing. And seniors in particular are not leaving empty-handed when you do that, I think, with full force. The next one, help me handle paperwork or documents. We all know that is literally really the hardest part for so many people, and an important role that we serve. Told me what others do or achieve in similar situations. So, and this was 9% of the respondents. And I think sometimes we forget we do this all day long, and people don't really know how things turn out, right? And so being able to help them assess their situation as compared to others, is this common? Is this normal? I once had a client who was in a divorce, and there was a battle over the list price for the divorce for the house. And she was so distressed and just couldn't believe that her husband was arguing with her about it. And I'm like, oh, every divorce has that in it. Of course, there's an argument over the price of the house. And she was just like, oh, really? And she said, that just makes me feel better knowing that this is a common moment in the progression of a case. So don't underestimate the value of your expertise when you can share that kind of information. Told me where to go to resolve my issue is the next one, and that's that 8%. Again, this is this problem-solving role that we play. And for pro se litigants, when we give them advice and counsel or brief service, oftentimes there could be a different resolution path than just the court, unless, of course, they've been served with paper. And so that is another thing, that your expertise is just this incredible wellspring for them. And then the last 4 did not do anything. 7% thought that their helpers did not do anything. Next is advised how to report the issue to an authority. Referred to another source of information or advice, 6%, and helped to reach out to the other party, 6%. And I want to pause again on what I thought was so interesting, that again, these are interviews with members of the public about their legal experience. And 6% said referred to another source of information or advice. Like we all know that we all refer constantly, right? There's almost no way you don't end up getting a referral from somebody for something. Yet they were placing the value, the thing that they took away, the thing that was actually something that they could get up on they helped me understand how to solve the problem, or gave me emotional support, or advised me of my rights and legal options. And so using this kind of data, and I want to, one of the reasons to share this with you is also to see like the real value of being able to do this kind of survey and polling work, because it helps us get a more nuanced understanding of our clients and where they're placing value, and where we, of course, still will do referrals, and they're essential and critical to everything we do. But don't think you're not doing enough when you just help them understand what's going on or give them emotional support. And we're going to talk in a little bit about the significance of that emotional support in actually being able to get through the legal case and solve their problem. So this slide is just sort of a different version. The data is cut slightly differently of the different kind of, they've used the word treatment, meaning the intervention or the thing that was done. And you can see the large blue boxes, gave me advice, light blue box, the dark blue box helped me handle paperwork. The orange one talked or wrote to the other side. That can be such an incredible thing. We know drafting a letter or making a phone call for somebody. And then here we see the referred to other resources at 9%. So it's just sort of a different way to see the sort of slice of the pie. And I know just and the age, you'll see that's blocked out to 60 plus. So just to remind you, these are all, I'm just pulling out the data from the 60 plus folks that were in this. Okay, this is a little bit of a messy slide, but this again really gets to understanding what's going on for our clients from their perspective of what they're seeing. To what extent did you experience each of the following as a result of your issue? And the surveyors had a long list of things, debt, and I'll just read them because I'm not sure how large this is showing up. Debt, harm to family relationships, harm to relationships within community, limited ability to work, loss of job, loss of money, loss of time, medical bills, negative emotions, negative impact on financial well-being, negative impact on mental health, negative impact on physical health, other physical injury to me or a family member, or violence against me. The bright pink is that it was a very large, to a very large extent, that they experienced that category. And when I pulled this slide, I set the needle at under seriousness, most serious, but it could be under less serious, and we'll see proportionally a similar result. The number one thing that they have experienced is negative emotions at 49%. And then the negative impact on their mental health at 38%. And then we have loss of money at 33%. And then we have negative impact on financial well-being at 32%. And 27% at loss of time. In other words, the impact of these legal problems on people's life really centers around, for them as they experience the event, around negative emotions, negative feelings, emotional distress, and includes money as well. But the number one thing by a long shot is negative emotions. And again, as we think about, and I just, the theme of this that I'm hoping you take away is that the fact that you might only be doing brief service, advice and counsel, or creating resources that are available on our website, if you think that's less than, from the eyes of the client, if that really is creating second-class justice, which I know some folks feel that it does, it's not. From the eyes of the client, if you can do anything to reduce this feelings of negative emotions and negative impact, then you have done a great thing for their life. If you go up and even see what we return to the earlier slides that talked about, what was most important. They helped me understand what was going on. They gave me my options. So these are soft things, as opposed to sort of hard data. Did I win or lose my case? So stress, it's the number one thing, right? Negative emotions. I think what this chart for me reveals is that people are under a lot of stress. That is what they're reporting. And of course, we know that as well. And acute stress, the research, and you can go and Google this and you'll find peer-reviewed studies on this, that acute stress negatively impacts executive functioning, and most notably working memory and cognitive flexibility. Typically, executive functioning has three major buckets: working memory, cognitive flexibility, and inhibition. Inhibition is less affected, regulation is less affected, but working memory and cognitive flexibility are most affected. And for somebody with a legal problem, that is exactly what you need to have, is cognitive flexibility and thinking about what are the options to solve this problem. And working memory is that short-term memory where you sequence steps. What comes next? What do I do? So this tells us that what they need almost more than anything from us is the kind of information and support that will supplement the deficits that they're experiencing in working memory and cognitive flexibility. So what could that be? So that's why checklists are so vital, right? That addresses the working memory problem. FAQs, something they can go back to again and again, breaking down a process and saying, first this will happen, then this will happen, then this will happen. That allows somebody to use a resource, and let's say you've written it and it's up on your website, but it can be printed out and handed out. Trusted partners who are not lawyers could hand that out. And we are supplementing the deficit that the senior is experiencing. Early on when we did the first word cloud, the issues of dementia and trying to keep track of things. So our resources can really focus on that, and we will be supporting them. Cognitive flexibility. I think where we support people the most on this is talking to them and just talking through the problem and coming up with options, and then reducing those options to writing in some way so they can take it away with them. If they have a friend or loved one who they could talk through the options, it gives them time and space to process what are the options to resolve this. So I'm going to stop there. We're going to switch to really talking about their justice journey, but I want to see if there's any particular questions that somebody or comments that anybody wants to offer at this point. And you can just drop them in the chat. Okay. Not seeing any.
No, nothing in there yet.
Okay. So the justice journey. And now, again, I'm going to do one of those word cloud things again with you. What are some of the challenges seniors have in getting help and resolving their problem? And so, because we're going to talk about in this section how they are actually traveling through this experience. So I'm going to stop and put another link in the chat, and then we'll put that up. So I'm going to stop the share for a moment. And just bear with me while my computer catches up. Okay, there's a new link now in the chat that you can click on, and now we know that there is a slight delay. So I will not worry about that.
I'll check the regular chat to see if anybody adds anything there. They're not.
Okay. I'm going to refresh. We'll give it just a second more, and then if it just remains stubborn for us. Oh, money.
Maybe that's what everybody sent in and only puts it one time. Did say they weren't able to access the link, but the challenge is affordability of legal help
Okay.
and whether or not it's cost effective.
So for the person like Valerie, who you put that in the chat, if you want to expand on what you mean by cost effective, because I think that's a really great point. Is that in terms of how the senior views it is actually getting the results that they want, that effort is worth the investment? Which I'm guessing maybe that's what you're talking about, but if you want to clarify more, that would be great. Okay, we have accessibility. Just give it one more second. Usually this loads very quickly. So that's, technology. It's only as good as it is until it's not, right? Too expensive to hire attorneys, or attorneys won't take the case because it's not worth it, right? Okay. Okay, I am going to go back over. Can you see the PowerPoint again? Kathy?
Yes, it's in full screen too.
Great. Okay, so money and accessibility is the focus that you all have, and I find that interesting because the people, whether or not they have money, if they have a problem that they need to resolve, they just have to go ahead and resolve it. That they don't really get a choice. That is one of the more frustrating things. And I think something that we try to keep in mind in pro se services is that they don't have a choice. They're going forward. I remember once running a pro bono program, lawyer in the day court program, and I recruited a number of private litigators to be pro bono lawyers, private family law litigators, to come and do a resolution for family law matters, sort of just a day. And then it's part of the Alaska Early Resolution Project, which you may have heard of. And when I recruited these lawyers, their first perspective on the whole thing was, well, there's no way we could go forward because we don't have discovery. And I said, well, we have a truck that is worth whatever the blue book says. They're going forward today. And it was a real eye opener, I think, for some of the private attorneys to see that regardless of whether or not the information was gathered in a way that is how we're trained as lawyers to do it, regardless of whether or not the people were ready, whether they had enough time to really think of options, they were going forward. And when we design pro se services, and thinking about the fact that everybody is pro se when they start out, right? If you have, if any of us have a legal problem percolating in our life, we're pro se until we decide we're going to go get a lawyer. And so designing our resources in a way that helps people find their path is one of the most empowering things you can do. And the question of if the lawyers don't think, I'm just going to put a crazy idea in your head. If a private lawyer doesn't think the case is worth it either, and that's just too expensive, are there things that we can do about those? Let's collect that information and let's talk about it as a community. And are there things that we can do when those kinds of issues arise? Are there simplification issues? Are there rule changes issues? Are there systemic things that we could do to better address the problem than simply saying you need to hire a lawyer to do multiple consultations? One of the places this kind of tension shows up often is for personal injury lawyers who get that do car accidents and get a lot of calls about fender benders, right? That the fender bender is never worth it to them, but they get lots of these calls. And I have seen practitioners in response then develop packets and pro se resources that allow the folks that call them to go forward in an informed way. And this basically becomes like a unbundled section piece of their practice. So that thinking strategically as we learn from the public what their challenges are, how can we solve the problem for them in terms of developing a better path? So let's talk a little more about what's out there. Katherine,
I think some people who are watching today may not understand what unbundled legal services is. Oh, you're getting ready to talk about that, aren't you?
Yes.
Good.
Okay, perfect. So again, and I'm trying to, in this session, because I think a cornerstone of doing pro se work is trying to put yourselves in the shoes of the pro se litigant. How are they seeing the world? And when they discover that they have a legal problem, if they've been able to figure out that they actually have one, there's basically 3 buckets of the kinds of help that one gets. And the biggest bucket is that first one, which I call asynchronous resources. In other words, it's web pages, it's handouts. Thanks to COVID, we all know this word asynchronous very well now, asynchronous communications. It's just a one-way communication. We have no idea when we have information on a web page, whether the person reading it understands it, whether they're getting the right takeaways. We know nothing. It's just it is very valuable to have out there and it's critical, but I just want to underscore, you really don't know when you're looking at asynchronous resources, how they fit into the bigger picture or if the reader understands it. So this is the same kind of thing. Many of us have probably gone on WebMD, right? That's an asynchronous resource. You go on, you type in your problem, it asks, gives you a bunch of information, and then you decide if you're going to escalate your engagement with that problem to whether you're going to go to the doctor's office, or maybe you're going to go to the CVS Minute Clinic because you've made some determination that the level of help for the kind of problem that you're facing you might right away need to go to a specialist, or maybe you need to go to your primary care, or maybe you can go to the nurse practitioner. And this is the same kind of thing that happens in legal. As in our context, though, we as legal aid lawyers and the providers of help to the poor, who really understand the nuances of the kinds of problems that poor people face, really do need to put a lot of consideration into what asynchronous resources we have out there, because that is the first place people are going to look. And what we want to have those resources do is, one, help give them a little guidance, and help them understand that there might be a framework or this is an issue, and just helping them identify things, and then also to help drive them to the right level of assistance subsequently. So the second bucket is what I call assisted self-representation. And this actually includes a number of things. If you have a wonderful senior hotline in Florida, and so when somebody is calling, or before they call, there's information on the page or from the legal help page. And then somebody's helping them understand what that information means, but it hasn't reached the level of any kind of representation being taken. So assisted self-representation could be somebody who's just a legal specialist, unlicensed legal specialist, right? Somebody who works, let's say, for a government agency who really understands how public benefits works. When they're talking to somebody and helping them navigate that process, in essence, they are providing assisted self-representation. It could be a family member. One thing, when I used to run a hotline, and one of the things we always did before we let people off the phone was say, can you, let's problem solve for a second. Let's identify a person in your life who is good at paperwork, who can help you with this process, because it's so overwhelming to the person who's experiencing it, and remembering that impact that stress has on our executive functioning. If we could just identify a friend or family member who happened to be good at paperwork, and we could be able to recruit them into this process. And sometimes people would say to us, oh, let's give them a call right now, and you could review, what are all the things I have to do, just so they have a helper and a support. That's assisted self-representation. If somebody goes to a library, and the librarian points out where the legal books are, and maybe helps people learn how to look stuff up, that's assisted. So it's anything that's just not all on your own, which is that first bucket. And then the final bucket, the smallest one, the most treasured resource we have, is our lawyer time. And it's representation, whether that's full representation or what we call unbundled. And unbundling is where a lawyer provides legal advice on a discrete part of the case and does not take the full representation of the case from A to Z. So in the private market, this is the difference between if you go to a lawyer and say they want a $5,000 retainer, and then they're just going to handle everything. You just give them the information they ask for and they handle the entire thing. Versus I hire a lawyer for a consultation. That would be unbundled. I hire a lawyer to look over some papers. That would be unbundled. Much of the work that is done, arguably, in the brief service and advice and counsel realm is essentially unbundled legal assistance. It is something less than taking the case for full representation through the trial or hearing, and taking, where all the attorney, the attorney becomes responsible for all aspects of managing the case. So one of the other things we see in these buckets, this is sometimes referred to as the continuum as well, because the responsibility on the shoulders of the self-represented litigant is changes depending where you are in this continuum, right? When they have a full representation attorney, most of the responsibility for the case is falling on the attorney. When you're only working with asynchronous resources, all of the responsibility is on the shoulders of the litigant, and nothing's on the attorney. Although I'm going to, again, just go back to this proviso that we, the attorneys, are the ones that write the asynchronous resources, that write the trusted resources. And that is why we want them to be so good. So we do have a responsibility to get good resources, good trusted resources into the field. So I'm going to stop here, because if unbundling is a new concept or anybody wants to ask any questions, I would be happy to talk more about this. This is something I had an unbundling practice for a period of time. So it's near and dear to my heart. So if you have any questions about how unbundling works. I think its value is, and we've talked about seniors not having the financial resources to hire an attorney for a full representation, but they might have the financial resources to do a consultation. A couple $100 to do a consultation with somebody if they've had others help them prepare, get their information in order, so they're not walking into the consultation, with the brown bag and all the scraps of paper, but rather somebody's helped them sort through it and they bring a discrete legal question to the lawyer. What it can do is it helps us get legal advice to people who otherwise might not get it. So it's a way of spreading our resources. And also, sometimes that's all people want. They don't want more than that.
And Katherine, somebody is asking, how are unbundled services priced?
Yeah, great question. So this is a point of, and I don't want to say controversy as much as debate amongst lawyers who do unbundling. The movement is towards having a flat fee of a menu of things that you do, and that is the most efficient and the most transparent and simple for the client as well, and most efficient for the lawyer. So going back to that example I was giving of the personal injury folks who do car accidents, who would create little packets for people that had low cost fender bender kind of things, but they still needed to know how to deal with the insurance company or anything else. They would have a packet that, let's say, somebody could buy for a couple $100, and you'd get some consulting, an hour's worth of consult with that. So and then in family law, there are many unbundled practices now that are getting fairly sophisticated menus of flat fees. They'll review documents, they'll draft a quadro, they'll do the child support. So it's a discrete task around a specific activity. You certainly, I think, powers of attorney, living wills, advanced directives, those things are really ideal if people in the private practice want to do those on an unbundled basis. Although I imagine in your jurisdiction, those are provided hopefully at no cost, through clinics or whatnot at senior centers. But for folks that can afford something, that would be a way to do it. So it's really around a task that you price it. Then there's other unbundled attorneys who do hourly rates. When I practiced, the focus of my unbundling was on court litigation, like when somebody needed me to go in for a hearing. And so I had some flat fees that were consultations, and then I did an hourly rate for my doing discovery or hearing time. And we have another question.
How easy is it to find attorneys who provide unbundled services, like to review documents or write a lawyer letter in a consumer case? And how would a client or a senior find them?
Yeah. So I actually don't know the answer for Florida. I know that this is really a state-by-state issue. It's a great question, and I am happy to do the follow-up legwork and get that information to Kathy and have her distribute it to attendees, because it is just such a hugely powerful thing for folks. So I will do that. And one way, though, in terms of the free services that legal aid programs can develop, in Alaska, Kathy mentioned I helped found an unbundled section of the bar. In Alaska, we had a list of lawyers that were willing to do limited scope work. And that's another limited scope or unbundled are sort of used interchangeably. And so we after, we talked to somebody, and again, it was a hotline. So we talked to somebody, got a sense of what's going on, gave them lots of forms and information about process, referrals, and all of that. And then if in their fact pattern, we heard that there were some legal issues, we would help them understand. And this particular thing this part of your case, you might want to talk to a lawyer about, and here is a list of lawyers that do hourly consultations. And we were able to hand that list out. And so there is a way to, I think legal aid programs are in an amazing position to be a pipeline to unbundled lawyers, and some who might operate at moderate means programs and so forth. And I think Jacksonville Legal Aid has a pretty well-developed program that Makita Green runs on some unbundled assistance around family law, some very discrete things, where the legal aid refers, and basically for their overflow, they can refer to these private attorneys who have reasonable rates to help people. So I love your question, because what it does is it really identifies for us the power of you being the pipeline, because you absolutely are. So this gets us to this other problem of who and what is trustworthy. So going back up, asynchronous resources, it's the big giant bucket. If you Google something, how do you know anything is valuable, right? Or trustworthy? We all come to think, I think WebMD might seem like it's trustworthy. But if you Google any kind of like how to get a divorce or consumer issues or whatever you want to Google, you're going to get a range of things back. And I love this cartoon, right? And if you, it's a little blurry, but what it says here is natural, free range. Then we have the actual turkey, organic, and heritage, right? All of these words kind of mean the same thing, but which one do you want? How can we tell what matters? And I think in your jurisdiction, this is particularly challenging because you have, the state court provides information, legal information for pro se litigants, which is great. But then at the local level, at the judicial district level, right, and the county level, you have the clerk's office often providing information, and you have the administrative office providing information, and you have a legal aid office providing information. So for the consumer, there's a whole bunch of theoretically, look like legitimate outlets providing information, but we have no idea how to tell what is trusted. And I think this is really the front edge of innovation right now for us as a field. This topic comes up a lot in our forms and technology group, where we have competing forms between entities. How is the public to know what to trust? And this really gets to branding, community outreach, and relationship building. That's how they're going to know. And so what I want to offer you is sort of a mindset of how you approach your work. The court administrator, when I started work at the Alaska court system, renamed the clerk's office the customer service department. It seemed like such a small thing, but when she did that, that realigned the entire way the court interacted with the public. And I've put on this slide, customer service is a thing. It's articles are written in the Harvard Business Review about customer service, right? I mean, the commercial sector, this is the heart and soul of being successful in the commercial sector. But I think there's a lot we can take away from this. And this is a definition that they give. It's the provision of service to customers before, during, and after a purchase. So think about how you're interacting with your clients before they ever reach you. That's that asynchronous side. During the time they're reaching you, and then after you've interacted with them, what kind of follow-up or what are you learning and how are you improving your systems? And the perception of success of such interactions is dependent on employees who, quote, who can adjust themselves to the personality of the guest. In other words, we just have to meet our people exactly where they are. And I think you all as providers to seniors, just do this naturally and very well. But it requires that flexibility and really listening. We are building trust. This is about relationship and trust building, our interactions before, during, and after. So what we put on the webpage, how the outreach we do to partners so they know our web pages exist, that is building a relationship and building trust with the community. What we do when we're speaking to them does the same thing. And then afterwards, do we learn when people tell us this doesn't work? Do we go and change things? The idea, whoops, I'm going to shift a little bit to kind of best practices now of how do we build this relationship building and trust building. You know, the gold standard, of course, is upstream and preventative. And I think looking at the kinds of services you provide seniors, right, you can see which ones of these you could try and get in upstream. And usually partners are going to be a key for that, but it is getting those powers of attorney and living wills and all of that, the advanced directives in place. It's understanding how the benefits, if you've just gone on some public benefits and somebody who hadn't historically been on them, understanding, you know, what assets they can have and what they can do with them. In the guardianship conservatorship world, you have a lot of people coming right to Florida who have guardianships from another state. Is that really going to work in Florida? So thinking about the places where upstream you can do something through that, and remember those asynchronous resources are hugely powerful. And in the customer service speak, the before the client, the guest, the customer gets to you. And so think about that and think systemically about what information you have. And as you do this, if you can make the time to do it, I know nobody has enough time for anything. But what will happen is that your work will, I promise you, start to shift from putting out fires to there's a plan, and you're going to put people on the course that they need to be on. Another best practice is trauma-informed approach. And this is, you know, gaining traction in all sorts of disciplines. Some of you may have had training in this in your jobs or, you know, your local programs already. I've put a link to some CDC overview document. But I included it here because I think when working with pro se litigants, this is exactly what we have to do, because at the end of the day, this very stressed out person has to carry the ball across the finish line by themselves. And so we see, you know, there's safety, trustworthiness, and transparency. Everything when we put information on a website that explains how processes work, when we have checklists, when we have process guides, that's creating transparency to the system. Peer support, connecting people to others that are experiencing the same kinds of problems. Collaboration and mutuality, collaborating not just with our clients, but also with the community they come from, that would support them, you know, right? So if you have somebody who's struggling with dementia and the Alzheimer's Association and the community is very active, maybe you're connecting with them. The fifth one, empowerment, voice, and choice. This is so important that we we empower them to make choices for themselves, especially seniors. They have lived a long life. They have wisdom. They have judgment. This is certainly not their first rodeo. And we should be supporting them and giving them information that will help them make the best choice for them. And then the cultural, historical, and gender issues, and being really mindful of those. And these documents, and there's lots of information on trauma-informed work nowadays, but there are documents that give very concrete steps of how to operationalize these ideas, and I encourage folks to look at them. So some more best practices. Establish procedures that force uniformity. Have an intake protocol that is everybody does it the same, and then you know why you have the process documents, and you know what's the same advice we're going to get, because this builds community trust. If one person goes to an entity and gets one answer, another person goes to the entity and gets another, they're not going to trust you, right? And they could have gotten the same answers, but they're not hearing it as that. So that's why you really want procedures that force uniformity, and designing intake protocols that quickly and unobtrusively obtain legally dispositive and relevant information And with senior work, this is tricky because we have to also take time, and I'm going to talk about that on another slide, to really engage in conversation. So I think from my perspective in doing pro se work, the intake protocol is the #1 most important protocol you're going to put together. It's going to drive everything you do. These should always be open to scrutiny and revision and improvement, because they set the whole tone for how the person is going to interact with the agency, but and the organization, but also how they're going to go down their justice journey. Create and update checklists, FAQs, and web-based information frequently. Checklists, FAQs, very simple things. Again, that being able to hand it out, they take it home, they can process it again. Recognize that people ask the wrong question. I practice primarily in family law. I've been through hundreds and hundreds and hundreds of divorces, right? I actually know the questions that come up. But sometimes because of the personal circumstances of somebody, the way that they frame something is quote unquote the wrong question. And as active listeners, then we can recast that into the right question so that they can get information that will help move them along. The no one leaves empty-handed. So we at Legal Aid have to turn away so many people. However, and I hope this has resonated through this presentation, the things that we do that feel like we're turning them away can actually be an enormous amount of help. So what I can do is, and if you can't help somebody, or if you have to turn somebody away, and even if this is done, and if you have some sophisticated automated tool in on your website, add what we can do is provide you this, and these will be the checklists, these will be the FAQs, these will be the referrals for other, if it's something that really first you need to deal with something else before you get to the legal system. Wellness resources, going back to that early slide that talked about that the negative emotions was the #1 thing that people experience with their legal problems. I think we as a community, because we're so focused on legal, we sometimes forget that, just giving some links to how to manage stress, or things being able to do, the quick tactical breathing that helps reduce stress when you're in a stressful situation, or what you do in court. If you feel like that, being able to do some deep breathing would help. There's a number of resources about how to manage stress and so forth. And that is essential actually to them having a successful legal encounter, if you will, and if they're in court, getting their case really heard by the judge, so the judge has the evidence the judge needs to make a decision on the merits. Because when you're under stress, you don't speak as clearly, or your ideas are jumbled. Go back up to that executive functioning is compromised. And so you don't get the right story out. You don't get to tell what you want to tell. And so I think seeing the idea that we provide resources for wellness and stress management as a core part of the legal package we provide is really a shot in the arm. And that, even when we have to turn people away, that is something that can live on a web page. And so that is something that you can do. And you all know this very well, partnering with those trusted people, senior workers, social workers, religious leaders, healthcare providers. But the little bit of spin I hope I'm giving you, or just food for thought from this presentation, is the idea, if you think of that customer service model, that the outreach you do to these trusted partners of telling them about your services, what resources might be on the pages, and so on and so forth, actually builds trust with the community before the contact even happens with your office. And it also, these people will come to trust you, and then they will get better and better at making more refined referrals. And then practical help to help people feel prepared. I think we lowball practical help all day long. It's my colleague Eduardo Gonzalez and I did work in Florida. I mentioned on the Justice for All grant. And he did an extensive interviewing with litigants in the court. And it was always the practical things. I mean, there was one gentleman who was convinced that his divorce was going to be denied because he didn't deliver the right copies to the right place at the right time. And he was in the courthouse. It was just like he went to the wrong department, and then they would find out he went to the wrong department, and then they would deny him. He wouldn't be able to get a divorce. It's this administrative stuff that really catches people up. So, and again, in the no one goes away empty-handed, we can memorialize in a standardized way transportation, how to get to the courthouse, parking, public transportation, ride shares, if senior centers can help with that. ADA and language access. I did go on the state court's website for their ADA paid form to request an accommodation. I think that is a very difficult form, and I would be surprised if people are really able to use it easily. And I think that's an area of advocacy for all of you to look at, and making an easy, streamlined process for folks that are hearing impaired or need other kinds of support and assistance. Anything under the ADA, same with language and getting interpreters. If one goes, when I have gone to judges around the country over the arc of my career, and I say, what is the number one problem with pro se litigants? And they say, service. They don't serve the other side. They don't understand how service works. They want me to just, rule before there's service. So really developing some materials that help make people understand this process of what, the purpose of service. The notice and opportunity, that if you get notice if something's going on, then you're going to have an opportunity to respond. And, we used to teach it really as a constitutional issue. We'd say this is due process. Everybody has to, get notice that something's going on, and without notice, you can't have an opportunity to respond. And these are the play fair rules. We put this in plain language for folks, that service really is the backbone of playing fair, where everybody knows what's coming next. Just to get it into their heads that everything has to be served on the other side, how many copies you need, making extra copies that they can take, when to speak and how to speak up in a courtroom in particular. I think this has gotten increasingly complicated for anybody that's doing Zoom court. So I'll just flag that, but that is, again, a handout on that of just really the practical guide of how to speak. What comes next? Nobody should ever leave a courtroom unless they understand what comes next. And so preparing people to ask that question, what comes next, is really important. And, typically judges will respond to that. But if you don't, then things, this is how we get people sometimes who went to their final divorce hearing and never got divorced because the final decree never issued for some reason. FAQs on things that when things go wrong. In other words, when you miss your hearing, what would happen? If you were late for your hearing, what would happen? If you don't serve the other side, what will happen? Sometimes doing an FAQ sheet on what will happen when things go wrong, it helps people understand, how to put it into a broader context, and might also, as lawyers, we know how to fix things, right? I know I need to make deadlines, but I can amend. That is a move that most people do not know, most lay people. So, the importance of what goes wrong? I didn't get the information I needed by the date that the judge wants it. What do I do? You still file on time, and then you file what you've got, and then you can amend and supplement. So I think that, that's another way to really support people. Just some communication tips. And I think these really go, hand in hand with the thoughts around trauma-informed work. First, validating fear and distress. Recently, I've taken it, upon myself to look around at self-help websites around in courts around the country. And if they have anything on there that says, when they're like, here, welcome, you're at the self-help website, we know you're going through, something really difficult, and we're really sorry. This is a hard time in your life. This information has been developed and blah, blah, blah. Nobody does that. We never, as a sector, do we stop for a moment, because this is where we work, but this is only where they're visiting in a moment of real fear and distress. Holding space for the client's story. And a lot of times they just have a bigger story to tell you, but there's a finite issue. And again, we're dealing with seniors. So sometimes they get that. They just need to tell the whole story. They have a lot of life experience, and they're willing to accept there's just a very little thing that either can or can't be done. Active listening, I think, with seniors is so important. Repeating back, okay, I understood. This is what I understood you to say. Is that correct? Asking them what outcome they would like what would be a good outcome to the problem presenting, because sometimes the outcome that they want is not necessarily one that it's not the win the case, it's something else. And I think being really mindful. I've talked a lot about being practical and collaborative, creating options, being really clear about deadlines. We're a very deadline driven business. The rest of the world does not work on deadline the way we do. And this whole notion of meet your deadlines and then amend or supplement. Always a written summary of what comes next. What the judge expects, so the 5 W's. I mean, these are tremendously useful, because what does the judge expect? Who will be in court? What will be addressed? What are the practical and administrative rules? What assistance do you need? Why do you need, all these sort of step-by-step stuff is worth its weight in gold for a pro se litigant. With Zoom court, I will just note that I heard some feedback, and it was actually from a colleague of yours in Florida, that somebody, where there were all the faces on the screen, and the client was like, are all of those people against me? So if we're doing Zoom things, I mean, who will be in court, who all those actors are. In person, sometimes it's a little easier because they're set around the courtroom. On Zoom, it's impossible. It just looks like there's a lot of people against you. But either way, helping people know that. And then technology, this could be, I'm sure, obviously a session of its own, and you've probably had some sessions about this. The digital divide issues for Florida seniors are enormous. And so there's a lot of supportive work that you need to do with that. And I think you might have seen the digital divide dashboards that we have done on the data, mapping the data for Florida. I'll provide those to Kathy as well, and the resources, and that you have them, because you can get right down to the county level and see what's going on in your county, and you can have facts to then engage, whether it's court officials or other government officials, about the reality of the kinds of supports that people will need in order to proceed. And no one leaves empty-handed, and that's it. And I see we have about 3 minutes left. So are there questions or comments that people want to share?
I don't see anything yet, but what about non-lawyers? What advice would you give to social workers, aging advocates, librarians, who a senior comes in to see them or has business with them about, but they talk about a legal problem? What advice would you give to non-lawyers?
Thank you for that question. And I know that that's a particularly important question in Florida. You have very rigid UPL laws, and it's scary being a non-lawyer. And when I was crafting this presentation, I was really trying to hold you in my thoughts. And that is why I was underscoring how what people say is most helpful is the emotional support, is the what comes next. It's the checklist, it's the pathway. If you did not write the checklist, if the lawyer colleague in your community wrote the checklist or the FAQ, and you just handed out because this was some resources legal aid gave you, you should be fine, right? But what they really also need is that emotional support, and breaking down a problem, getting the opportunity to just talk it through. We can use active listening and not advise people, right? We can just listen and be a mirror and help them talk through a problem. And I think sometimes people, what they really need is so much administrative kind of help, copies and things like that. Again, clearly not legal. So I hope you can pull out from this that what people are looking for and the huge high value is, especially given the executive functioning deficits and the trauma issues that are going on while somebody's encountering a problem. The non-lawyers in the audience are probably, in fact, better trained to provide support and help on that. The lawyers, we can get very task-oriented and skip over it. What do you mean? How do you feel? Let's do this. But it turns out the how do you feel is and giving people support in that is probably going to make them better in court, because they're going to be ready to tell their story completely to the judge. And that's really all that's going on in court, is telling the story.